Since the reports in the newspaper, in the Mail on Sunday, last Sunday week, we've had one document and what we've had the two ministers at the start of this debate. We've had two statements from the government since then. The AG's report, which I'll speak to shortly, which was utterly disappointing, and the ministers this afternoon, who have ricocheted off the central injustices that have been exposed and discussed, rather than grappling with them, accepting them, and detailing a path with which we need to travel. Look, in the reports last Sunday week, it was revealed that successive ministers for health, departments, and indeed stood over by governments, have maintained a secret legal strategy to block or minimise compensation to older persons and their families who were or who might have been illegally charged for nursing home care. The issue, as we know, has never been tested in court, and the lack of a test case is because of the state's aggressive legal strategy made sure that no case could ever get to a full court hearing. As the 2010 Ombudsman's report suspected, and as the government's information note confirmed, that's the government's information note last week, cases were settled before discovery, before the publication of any documents, to avoid encouraging more cases to be taken. A central part of the injustice is that it clearly occurred that people who had the resources, personal capacity, money, agency, links to challenge the fees had them quietly dropped, whereas other people, those who didn't have the personal capacity, didn't have the money, didn't have the links, and who may have even been in the same nursing home, may have been in a room or a bed next to the person that did, continue to be charged, sometimes for years, and sometimes with major consequences for families, such as being forced to sell homes, farms, or businesses, or other assets. As the Ombudsman's 2010 report found, many people over these decades have been deprived of their legal entitlement. Access to nursing home care over this period has been marked by confusion, uncertainty, misinformation, inconsistency and inequity. The Ombudsman was deeply concerned about what the issue suggested about how adequately officials were briefing their ministers and the whole nature of the executive-legislative relationship. While the 2009 Nursing Home Support Fair Deal scheme put in place a new fees regime for nursing home care, it did not address the fundamental inequalities and injustices that occurred from 1970 to that date. The issue is not just that people were or might have been illegally charged for nursing home care, but that the illegality was known for decades and officials just kept going. And now we discover that there was an aggressive legal strategy to frustrate access to justice for people affected. On the question of medical cards, the Travers report notes that those with the medical card were not required to pay inpatient service charges, but institutional assistance charges were payable. Those not fully eligible, i.e. not in the possession of a medical card, were liable to pay both. The Travers report makes it clear that the 1976 circular from the Department of Health tried to work around the law rather than amend it. That circular instructed officials to remove medical cards from people in long-term care, thus depriving them of the criteria that would make them fully eligible for free of charge care. This ignored the fundamental illegality of the charging regime. For example, in section 3.2, a central feature of the legal concerns has been that the use of secondary legislation in the form of ministerial regulations as a means of setting aside a substantive provision of primary legislation is ultra vires. It is not clear that the 2006 health repayment scheme included all relevant cases. The view is that the terms of reference were very narrowly written for that repayment scheme in order to minimise numbers who could apply for compensation. The information note about the legal strategy suggests awareness that a much larger cohort of people could be eligible for compensation. Around 20,000 people were compensated through the 2006 scheme, whereas potentially 250,000 plus were affected by fees since 1970. The 2006 scheme also has a cut-off point of 1988, with people charged before that date not included, and there is no explanation as to why this is the case. A complicating factor about medical card holders being entitled to free of charge care in public beds is that the state had public beds in public facilities, the state publicly funded beds in voluntary and not-for-profit private nursing homes, and the state had publicly funded contract beds in private for-profit nursing homes, potentially in the same building as non-public private beds. Were all of these types of beds included in the 2006 scheme? Another gap in our knowledge is the detail of the subvention scheme that existed prior to 2009. Part of this appears to have involved means testing the wider family of people in nursing homes, with adult children being asked to contribute to costs. This seems like an extraordinary overreach in terms of means testing a person's children before giving them a subvention. So these are still things we do not know about this scheme and about this area, and the lack of publication of documents in relation to this, since this has come back into the public consciousness last Sunday week, is a huge cause for concern. The Labour Party does support Age Action's call that we need the establishment of a Commissioner for Ageing and Older Persons as a matter of urgency to strengthen the institutions of the state that are independent of government, so that such scandals that we're discussing now cannot happen again. We already have commissioners in Northern Ireland and in Wales with proven track records to serve older people. On the AG's report, this was massively disappointing. The AG's report seeks to conflate the interests of government with the interests of the state by, for example, invoking the taxpayer as a client of the Attorney General. The report places undue and inaccurate emphasis on government policy rather than legislation as the basis for spending decisions. It is quite simply wrong to say that, quote, in the ordinary course, expenditure on social protection and health is a matter for government. It is more accurate, instead, to insist that where legal entitlements are spelled out in Health and Social Welfare Acts, the government must seek the funds to meet that expenditure, or else seek to have those acts amended. There is no other policy option. It confirms that legal professional privilege has not been waived by the government, and so the AG cannot provide any details of the advice provided. While more or less conceding in the report that medical card holders should not have been charged for their stay in public nursing homes, the AG maintains that there is a viable legal defence when it comes to private nursing home residents. But the AG seems to be demolishing an argument that no one has made. The AG says at no stage did the Oireachtas ever legislate in 1970 or otherwise to make the provision of private nursing home care free to all persons in nursing homes of their own choice. But no one has ever argued that. What is being argued is that if the state fails in its statutory obligation to provide a public placement and instead places someone in a private nursing home, the individual residents should not be out of pocket. The argument is not recognised or addressed in the report, and it's a fundamental failing of the AG's report. It is nowhere explained why, if the state had a bona fide and viable defence, that it was prudent to settle so many cases, with not one single one proceeding to court. To a court hearing. Quite simply, this lacks total credibility. So what we would like to see? We would like to see full transparency with all documentation to be published to get to the root of this and why things like this are happening over and over again. As the recent revelations show, the state approaches litigation in a manner which is indistinguishable from any faceless private corporate entity. It is a war of attrition against those who dare to sue it. There must be a change of approach. There is a clear and compelling case for splitting the Office of the Attorney General in two, to separate the task of defending the interests of government departments from that of representing and defending the public interest. The AG is not in the same position as a commercial law firm. Defence strategies for litigation against the state have to be prepared with a proper consideration of the public interest. This must be a watershed moment in Irish politics, and we must make the necessary changes to stop vulnerable people being let down by the system. The most effective way to reprioritise the public interest over cost containment is to empower the Office of AG to draft strategies to defend the public interest just as doggedly as it currently pursues the more narrow interests of government departments. So my view is that the aggressive legal strategies designed to quash, suppress or minimise entitlement or eligibility for any citizen is something no government should stand over. This government, any of the past governments, including governments that my party have been involved in, and indeed any governments into the future. In the case of the disability allowance payments, in which it was a direct action not to trawl through state records to see who should be entitled to redress or justice, this again is an action that any state body government cannot stand over, and as such, no government past or present can stand over it either. True transparency and openness in public life is tested with issues like this. That is why whistleblower legislation and freedom of information legislation, which we did bring in, is good, but exposing the mistakes and bad decisions of the past is not enough in and of itself. We need a path to make up for these mistakes, and this is an opportunity to do that. And it is not enough when something like this is raised, as it has been over the last a couple of weeks, that the government will list out other areas where they have met a historical injustice. and put in place a redress scheme or whatever the case may be. It is with each new case that we need to ensure that we meet that injustice and put something in place. We still need to see documents. We still need this to go to the Health Committee or the PAC and to be discussed more in the Dáil. This Thursday afternoon debate cannot be the end of this, but this should be a watershed moment. These legal strategies, well, the government and state should be entitled to defend itself against mendacious or nuisance claims. When it comes to real issues where the government's legislation, where the state legislation is flawed, failed or weak, the state needs to be open and transparent and act in the interest of the individual and not in the narrow interest of its own department. Thank you.